All right, now we turn to the fund's position, or as I said before, it's my interpretation of the fund's position. So let's start with judgments. When you think about judgments and ladybird deeds, it's almost like you have to think of the opposite party we're talking about, because that's who it's really going to affect. So for instance, if you create a ladybird deed, and then let's say there's a lawsuit that's filed against the life tenant, and then the judgment is recorded after the creation of the ladybird deed, the fund will want that judgment cleared before the remainderman could sell the property in the future. But if the lawsuit and the judgment come after the creation of the ladybird deed, then the fund will disregard that judgment in the future when the life tenant dies and the remainderman goes to convey the property out. Now, judgments against the remainderman are a little bit different. And the fund's position, which was in some articles that I had read and which I have in my material, state that they will look at judgments against the remainderman on a case-by-case basis. But they've expanded it a little bit, I'll talk about it a little bit later. They're going to be looking at whether there's a fraudulent conveyance, and the real threshold issue is, does the creditor acquire a greater interest than the interest held by the remainderman? So in other words, if the remainderman can be divested of his interest, then why shouldn't the creditor be divested of a judgment that's recorded against the remainderman? Well, the creditor would have the obvious argument and say, well, wait a minute. If this is a vested remainder, which the fund says it is, then while it was vested, if the creditor recorded their judgment in the public records where the county is located, then at that time it should create a lien on that property because it was vested at that time. So even if the life tenant can divest the remainderman of his interest by conveying it to a third party for consideration, can you then say to the creditor, well, sorry, you did have a lien, but now it's just disappeared? Again, these are the cases that we don't have, that we don't know the answer to, but you can see there's an argument on either side. So the fund is going to be very careful with regard to judgments against the remainderman. With regard to federal tax liens, the fund is very clear on that point. The IRS has become extremely aggressive in terms of liening property to get their taxes paid. If there is a federal tax lien recorded against the remainderman, they're going to want that cleared, regardless. Now, when we talk about the death of the remainderman prior to the life tenant, there's some different possibilities here. If, let's say, somebody creates a ladybird deed and you just have one remainderman, well, if that remainderman predeceases the life tenant, you're going to have to probate the estate of that remainderman, because if he had a vested interest and he died, then you have no choice. If there's more than one remainderman, so let's say you have two children and both of them are remaindermen, that's going to depend. If you draft it as joint tenants with right of survivorship, then it will pass to the survivor. If it's tenants in common, which is typically the case because most parents want that interest of the child not to go to the other child, but maybe to go to that children's heirs, then you're going to have a tenancy in common, and then if one of the remaindermen dies, you're going to have to probate their estate. With regard to homestead property, and now the setting that I want to discuss is where you have, let's say, homestead property from the standpoint that you have a husband and wife and it's owned by one of the parties. If they create a ladybird deed and they're survived by a spouse or a minor child, you're going to have a problem there, because it may be a contingent remainder. Now, I've been saying it's vested, but nobody really knows. It's not as if there's a case that makes it that clear. The fund's position from their research is that it's vested, but it might be contingent. And if it is, it's going to violate the Florida Constitution when that person dies, when the life tenant dies, because you're then devising an interest at death when you're survived by a spouse or a minor child. So that type of ladybird deed is not going to work. you're going to wind up getting releases from everybody involved. The Florida elective share, which was expanded in October 1st of 2001, as I'm sure all of you know, has created this idea of almost like an augmented estate, whereby before, if somebody died and the assets were not subject to probate, they were not part of the elective share. And as a result of that, the elective share statute was rewritten and expanded to include just about everything. Now, there are some exceptions, like if you transfer property and it's out of someone's name for a year, it may not be part of the elective share. But in this case, because it's kind of like a revocable trust, which is included, as we know, as part of the elective share, this is the same thing. It's revocable because you can divest the remainderment and give it to somebody else. And so the fund believes that this will become part of the elective estate. And so if someone dies and you set up a ladybird deed and it's going to go to somebody else, you're going to need a release from the spouse because they're going to feel that it goes into that computation.